Good afternoon, everyone. My name is Kathleen McGovern. I'm here representing the PCAOB's Division of Enforcement and Investigations. Because I'm standing between you and lunch, I'll try to move at a reasonable pace. As Kent said earlier, the views I express are my own and don't necessarily reflect the views of the board as a whole, any individual board member, or other staff. Just a little bit about what we do on our mission. At the Division of Enforcement Investigations, I have the privilege of working with highly dedicated accountants, attorneys, and other professional staff. And we serve the board's goal, which is to protect investors. Our division is authorized to investigate the registered public accounting firms and associated persons for non-compliance with Sarbanes-Oxley SOX, our rules, the SEC's rules, as well as other laws, rules, and professional standards that govern the audits of issuers and broker-dealers. And we use that investigative authority to identify potentially serious audit deficiencies and other potential violations of those relevant laws and rules that pose significant risk to investors. Our goal at the end of the day is to sanction and deter non-compliant auditors and others similarly situated from violating those applicable rules, standards, and laws. And at the end of the day, it's to promote compliance within the profession, and again, always to protect investors. Today, I'm going to discuss the enforcement program statistics for 2024 and basically up to date through this year at the end of March. I'll talk a little bit about the range of potential sanctions and the effect of suspensions and bars and certain consequences. I'll talk about a subject that's near and dear to my heart, is always coordination with the SEC and other regulators. I'll talk a little bit about our priorities for the enforcement program, and then I'll close out talking about some matters that involve quality control violations, exam cheating, and I'll highlight some of the noteworthy settlements from the last year and a half. So just a little bit about our program statistics. An overview of 2024, there were 51 public enforcement orders issued, which was a slight increase from 2023. About 40% of those involved firms or associated persons that were outside the United States. 5 of those orders involved firms that settled to charges with regard to exam misconduct and professional training or accreditation. And just through the end of March of this year, there have been 19 public enforcement orders, including one that involved exam misconduct. And again, this just shows a little bit about the trends. Public enforcement orders, the numbers have steadily increased, and you'll see on the other side with regard to the monetary penalties, those have increased somewhat significantly. I'll talk a little bit about one of the enforcement actions that took place in 2024 that accounts for a large number of that $35 million in monetary penalties. Just a code word, 22 is 425, that's 425. And just going right into the range of possible sanctions, this slide just talks about the different types of sanctions that are available to the board for sanctionable conduct. And in addition to the sanctions that we hear about a lot, the monetary penalties, suspensions and revocations, I just want to focus and highlight the availability of some of the other sanctions that are a little bit more forward-leaning and we don't hear about so much in the past. We're hearing a little bit more about it, and that's proactive undertakings, which would include changes to policies and procedures, certain training, and the use of and the implementation of an independent monitor or an independent consultant. I also just want to highlight with regard to the effect of suspensions and bars, that it's critical to understand that with regard to the PCAOB suspensions and bars, some firms have actually been sanctioned for allowing individuals who are suspended or barred from associating with registered firms. They're also not allowed to hold specific positions within issuer companies in accountants or financial management capacity. So again, just want to highlight that for you all. Just a few points about the program outlook. Similar to that of the last several years, we have a continued emphasis on significant sanctions for conduct. We, at the Enforcement Division, continue to prioritize investigations that involve significant audit violations that, again, present risk to investors. We look to matters that threaten or erode the integrity of the board's oversight process, as well as audit matters that relate to significant independence violations. And in addition, we're also focusing on particular deficiencies in firms' quality control policies and procedures, which I'll talk about in just a couple of minutes, and audit matters that relate to some new and evolving issues, for example, the use of crypto assets. I just want to talk for a minute about matters involving deficiencies in a firm's quality controls. Since about 2019, enforcement has been specifically focusing on these matters that relate to deficiencies in firms' quality controls, policies, and procedures. Firms have the responsibility to ensure compliance of its personnel with professional standards, and a proper system of quality control provides firms with reasonable assurance that they will. During 2024 and through February 2025, the board issued over 40 settled orders that involved violations of quality control standards, and they involved both U.S. and non-U.S. firms. They included quality control issues around all 5 elements: independence, integrity, and objectivity, personnel management, acceptance and continuance of clients and engagements, engagement performance, and monitoring. And I plan to highlight at least one of these settled matters when I talk about it in just a few more minutes. Here's a polling question. What types of exam misconduct and professional training or accreditation has been identified in public enforcement orders issued by the PCAOB? And I'll just give it a few minutes for folks to cast their vote. I think it's slowed down a little bit. So the answer is for all of them. They all apply. There have been public enforcement orders with regard to misuse of emails, joint examinations, tests, and instant messages, shared drives, automatically inputting the correct answers, and software to input answers until the correct answer is found. So good job, everybody. Just to follow on and talk a little bit about matters that involve the exam misconduct. Through February of this year, the PCAOB issued 10 public enforcement orders that involved registered firms and 2 orders involving associated persons concerning exam misconduct in professional training or accreditation. All of those registered firms involved were foreign affiliates of global network firms, and the associated persons were senior management of those firms. In many of the cases, the misconduct occurred over multiple years, involved both staff and partners, and some involved those leading the firm's system of quality control. And I mentioned a few minutes ago about the 2024 KPMG Netherlands order was particularly troubling conduct. That was a $25 million penalty that was assessed, again, a part of that 2024 overall total of $34 million. That was multiple uncorrected misreps to the PCAOB for over a year. The code word 23 is 290, 290. I'm just going to take a minute now and also talk about coordination with other regulators. The board coordinates its enforcement efforts with the SEC and can share information with other regulators as well as the Department of Justice. Coordination with the SEC enforcement is pretty much standard practice within our division. It can result in parallel investigations, for example, where the PCAOB investigates auditor conduct and the SEC investigates the issuer, the public company, its management, and others. Or this can be vice versa. The PCAOB has also negotiated cooperative agreements with audit regulators in many foreign jurisdictions to facilitate the collection of evidence, sharing information, and charging of respondents. Some of our foreign investigations result in parallel investigations as well, where the board investigates potential violations of our rules and standards, while the foreign regulator investigates potential violations of their rules and standards. And with regard to our international cooperation on enforcement, there are cooperative agreements that are expressly between the PCAOB and its foreign counterparts. And they generally have provisions for access to documents and information that are necessary in our investigations, including audit documentation and testimony. They include strict confidentiality provisions, in part to address the confidential nature of the board's enforcement. And they help address unique non-US legal requirements, for example, personal data protection laws. They also provide a framework for resolving conflicts. And the PCAOB in the last couple of years has entered into dozens of cooperative agreements across the globe, including most European countries, Canada, Japan, and with Chinese authorities. There's a complete list on our website with regard to those cooperative agreements. And now I'll just take a moment or two to talk about some of the noteworthy settled matters in the last year. So the first one I want to talk about is Halperin Ilmenite CPA, which is a violation of quality control systems. It's an Israel-based firm that violated PCAOB's rules and standards in 5 audits of 3 issuer clients. And the firm's owner and only partner was directly and substantially involved in these violations. It also violated PCAOB's rules and standards. She also violated PCAOB's rules and standards in her role as the engagement partner in those audits, including failing to obtain engagement quality reviews, failing to obtain sufficient appropriate audit evidence in auditing the valuation of significant accounts, failing to make required audit committee communications and assembling a complete set of audit documentation, and failing to timely file Form 2s and Form APs. As reflected in the numerous violations spanning a number of issuer audits, the firm's quality control system failed to provide the firm with reasonable assurance that the work performed would meet the applicable standards. And the sanctions I just want to raise were just monetary penalty, revocation of firm registration, and a bar for that partner. The second matter I just want to highlight is Malone, in the matter of Malone Bailey, and that was May of last year. And the conduct there involved from 2018 to 2021. There were 3 inspections of the firm, and each time the board notified the firm of significant audit deficiencies that raised concerns about engagement performance. And despite the awareness of the firm as to those deficiencies and concerns, the firm failed to make the effective changes to improve its quality control system. And as a result, the sanctions included a monetary penalty, but I just want to focus on, as I mentioned earlier, some of these other sanctions. And here, it was the imposition of mandatory training, and then the imposition of an independent consultant. The third settled matter I just want to highlight is in the matter of Navarro, Amper and Company, which involves Deloitte Indonesia and Deloitte Philippines. That's with regard to exam and answer sharing misconduct, and it occurred from 2017 to 2019, where at least on 6 occasions, partners who were responsible for e-learning compliance shared answers to training assessments with other audit partners. Obviously, there was a misconduct from misconduct, inappropriate tone at the top, and a failure to effectively monitor quality controls. And it also involved its national professional practice leader. And there, the sanctions included a $1 million civil monetary penalty, and then a 3-year bar, and a penalty for the monetary penalty for the partner. The next code is 990. That's 990. And finally, the last matter that I want to highlight is Rains and Fisher. And that's the conduct there, the misconduct there was in anticipation of the 2020 and 2022 PCAOB inspections. Firm personnel improperly created and modified numerous work papers after the applicable documentation completion date. The engagement partners of those audits were responsible, principally responsible for the work paper alterations. And in both of those instances, the firm managing partner was actually aware of the alterations and took no action. And so with regard to that, the sanctions included permanent revocation of firm registration, a civil monetary penalty, and then a 5-year bar for the engagement partner, and then a 3-year bar for the EQR and the managing partner. There's another polling question. I think we've given people a chance to vote. The Sarbanes-Oxley Act requires monetary funds collected by the PCAOB as a result of enforcement be used to fund scholarships for accounting students for the 2025 and 2026 academic year. About how many schools are eligible to nominate a student to become a PCAOB scholar? And the correct answer is D, about 500 schools. And just the final topic I want to mention is the PCAOB Center for Enforcement Tips, Complaints, and Other Information. The contact information is on this last slide. It's an important part of our work to ensure investor protection. It's one of the areas under kind of my supervision. And as Vasilya mentioned before about the SEC, it's a valuable tool in terms of rooting out misconduct and ensuring investor protection. So we encourage you, if you have information, a tip or a referral, to reach out to any of these noted methods. And I'll just share with you that, recently, we do a lot of work with our TIPS program. Recently, we had folks contact us, and we were, as a result of this matter, we were informed that we were really the only regulatory agency that contacted the tipster back, and it really made a big difference in terms of kind of the attention that was given to it, and hopefully the enforcement action going forward. So that concludes my presentation. I'm happy to take a couple of questions, or you can, I'm looking at Brian now, and we can proceed to lunch if there are no questions, I think.